2000, when Mr. Saldaño, along with all death row inmates, were transferred to the newly built Polunsky unit. There, no physical contact or communication between inmates is possible. The isolation is total and extreme. The cells measure 5.4 square meters. That is a room of 6 by 10 feet, including the built-in cot, laboratory, and toilet. This tiny space is enclosed by a solid door that reinforces the isolation. Under this regime, a year later, by 2001, Mr. Saldaño had suffered an abrupt change in his mental aptitude, followed by his first suicide attempt. He also experienced a weight loss of over 20 kilos. At the time, disciplinary actions by prison authorities left Mr. Saldaño unable to receive visits, no access to limited recreation, no access to the prison store, and during prolonged periods, he was subjected to a cold diet consisting mainly of peanut butter sandwiches. After his first suicide attempt, Mr. Saldaño was transferred to the psychiatric hospital for several months. This will be the first of 9 hospitalizations. Since his first crisis, his mental problems never stopped and led him to a self-destructive attitude where he was unable to maintain the most minimal and elemental hygiene and regularly refuses food. During his trial in 2004, Mr. Saldaño again displayed clearly bizarre actions. He refused to change out of his prison garb. He masturbated inside his pants in front of the jury. He was distracted, looked disheveled, smiled inappropriately, moved his lips without emitting sounds, and was unable to assist his lawyers in his defense. In our view, it is hard to understand how clear signs of a mental illness that had been previously documented by a physician from the state psychiatric unit were dismissed by the court. In 2006, Mr. Saldaño suffers a new severe breakdown, and he is again hospitalized, this time for the 5th time. For several months, he is incoherent and has difficulty in understanding simple phrases. Dr. De Leon from the psychiatric hospital informs the consulate that Mr. Saldaño has been diagnosed as suffering from a schizophrenia, since his behavior of hearing voices, smiling in an irrational manner, and moving his lips in an intermittent way without emitting any sound were clear signs of this disorder. This is the first time that the prison authorities recognized Mr. Saldaño's mental illness in front of consular officials. But this conduct was not new. This same conduct had already been made evident during his second trial in McKinney, Texas in 2004. 2007 brings new suicide attempts when he tries to hang himself with bed sheets. While Mr. Saldaño is at the psychiatric hospital, he receives medical attention, is under a less strict regime, and some improvement in his condition is evident. He later decompensates when he is transferred back to the Polunsky unit. The Argentine consulate continues with its regular visits to Mr. Saldaño and continues to witness the physical and mental deterioration of Víctor Saldaño as the result of his time on death row, and as evidenced by the visits and medical documentation to such an extent that it's difficult to recognize him as a person. Thank you.
Thank you. And I'm going to address the legal arguments primarily presented by the U.S. government. First, the requirement under international law is that the status quo ante be restored in the event of a serious violation of international law like the racial discrimination that took place at the first trial. In fact, the Inter-American Court has gone even further in the Hilaire case to directly say that in cases of serious procedural violations, there shouldn't even be a retrial. The status quo ante clearly was not restored in this case. We're dealing with a situation whereby the second sentencing trial, the decline was so pronounced he simply wasn't able to assist his attorneys, and worse than that, he was scary to the jury. And one of the issues that the jury must address in Texas is future dangerousness. How can a jury correctly address future dangerousness if they're faced with someone sitting at the defendant's table who's masturbated, who's disheveled, who's distracted, and they don't hear a word about why. The basic approach of the United States government in this case seems to be that the protections of the U.S. Constitution and the U.S. court system are sufficient. Well, this is a case where it was only because of the Argentine government that the practice of having expert testimony associate race with future dangerousness was ended in Texas. The psychologist who testified at the original trial said in the transcript that he testified in some 70 cases. Not all of those would have been cases on the issue of future dangerousness, but we know of at least 8 other cases that were reopened as a consequence of the press from this case. This case came to the attention of the world thanks to an Argentine legislator who was present at the trial and an Argentine consulate that pushed for a direct appeal on the issue in spite of the fact that there was no objection presented at trial. Rather, there was cross-examination on the issue of whether Argentines are from the same bloodline as Mexicans and therefore represent the same future danger. The district attorney from that case, when I called him to the stand at pretrial in 2004, continued to insist that it wasn't racism. It was just scientific testimony that had been earlier presented. The Court of Criminal Appeals, when I appeared before them after the 2004 trial, began their questions to the prosecution with the question of, isn't this case like the story of the son who kills his parents and pleads for mercy that he's an orphan? That was the first question out of the mouth of the Court of Criminal Appeals judges to the prosecution. Today, the United States government is offering habeas corpus as a solution, but it's really a fig leaf unless we get their direct support. The odds of being successful in habeas corpus today in the Fifth Circuit are around 5%. The vast majority of those cases that are successful aren't cases involving the sentencing stage. They're cases involving the guilt or innocence stage. The standard for habeas corpus is a need to show that the decision below was unreasonable. It's a very, very high standard of proof. Only about 5% of habeas corpus cases get an evidentiary hearing. We need an evidentiary hearing if we're going to have any hope of success. It's true, as the U.S. government brief argues, that U.S. law bars the execution of persons who are incompetent. Unfortunately, Texas has now placed Víctor Saldaño on a medical regime that does give him some periods where he's lucid. So what am I to do now as an attorney? Am I supposed to advise Víctor Saldaño, along with his other attorneys, that he should stop taking his medication so that once again he's no longer lucid? And believe me, the best way for Víctor to face the endless days in a 5.5 square meter cell is with medication. He wants that medication. This case was extremely politicized in Texas. There was an open battle between the Attorney General of Texas, who conceded error in the initial case, and the Court of Criminal Appeals. Both Court of Criminal Appeals judges